Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another episode of our show. Today, we are very lucky to be talking to Zach Schorr of Schorr Law. Zach, welcome to the show.
Thank you.
It's a pleasure to have you. You are a real estate attorney and with experience in real estate litigation. Is that correct?
Yeah, but we do a ton of real estate litigation. I'm a real estate attorney, and sometimes that drags us into probate as well. So it should be topical for you.
Very nice. Excellent. Okay, so let's delve right into the meat of what I wanted to talk about. There are, we often, in our world of trust and probate and conservatorships, we often talk about the exempt seller and things that come up, the differences. So the first question that I wanted to ask you, can you tell our audience, during a standard sale of real estate, during the standard transfer of real estate, what is the transfer disclosure statement?
Yeah, that's a statutory mandated disclosure that you give. I think it's Civil Code Section 1102. It says it on the form if you're using the California Association of Realtors form. But it's basically a mirror of the statute, and you're required to give certain disclosures to the buyer about material facts that you may know of. Oftentimes in a residential sale, there'll also be a seller property questionnaire that accompanies that as well, that may go into a little bit more detail. But interestingly, and I'll let you ask your questions, but with probate, oftentimes you're exempted. I think you alluded to that from that. If I'm a professional trustee, for example, and I'm coming in to sell a property, chances are I don't know anything about the property. And so I'm exempt from providing those disclosures. But there can be different circumstances where if I happen to know something, then I'd still be obligated.
That makes total sense. Now, you mentioned something that comes up often in real estate transaction. The word material, the words combined, material fact. Can you tell our audience what is a material fact when it comes to real estate?
It's probably going to be anything that affects value. And I'm purposely saying probably because you can't look it up in some book and it says this is, here's a list of all material facts.
Yeah.
But you could put yourself in the shoes of a buyer or even a seller. And if, if there's a excessive noise from something next door, that may be a material fact. And so it's really not on the seller to decide. That would be my advice, what a material fact is. It's just anything that could potentially affect the value of the property. I would err on the side of disclosing that.
So if are you saying when in doubt, disclose it?
Definitely. And or at least give them enough information that they could investigate further. And that's the idea. I kind of view it as like a notice, like, hey, there may be an issue here. You go look at it, you ask your questions. And my view, ironically, is that the way California sets these up is there's an emotional commitment that people make to property, right? I'm looking to buy a piece of property. I finally get it, maybe a probate sale, maybe a traditional sale, and I've beat out all the other buyers, or I've been the highest bid. And I'm like, great, I'm getting this house, I'm getting this property, and I'm totally emotionally committed to it. And then you get the disclosures and you're like, whatever. And you should investigate. But the way it's set up is, in my mind, it really favors the seller and like give them all the information and they're already emotionally committed. So why not just give them everything?
And that's exactly what I do. That's funny that you bring that up, actually, because not everybody sells the real estate the way I do. We disclose everything prior to the offer and we let people pre-inspect prior to opening escrow. So we are working in general with multiple buyers that are inspecting a property. And then this is what we say, once you've done all your due diligence, then give me your final number. And that's how we're going to go into escrow with. Because sometimes, as you know, and it's not easy. I spend more time training other agents, buyer's agents, how to do this, because they don't know how to tell their clients, look, you don't have the house, but you can spend $350 to inspect or $500 to inspect it. And, it's an investment that it's worth it. But when we want to protect the personal representative and the successor trustee, and a lot of the times we work with professional fiduciaries who have no clue don't know anything about the house. So that's a very interesting point that you bring up. Let me follow up with another question
So
specifically.
it's also, if I can interrupt,
Yeah,
it's
absolutely.
super smart the way you're doing it, because, and I think Northern California more so than Southern California does it that way, where they'll actually go out, get the inspections. And if you're the realtor or the agent inquiring about it, then they drop everything on you and say, here it is, make your offer if you want to make it, which it's great that you're doing that. It should be more common.
Yeah, a lot of the sales that we work with, are court confirmed, and you never want to be in a position, where you petition the court and then somebody changes their mind, or whatever the circumstances. We unfortunately we see a lot of that, but not with our clients, but in general when we go to court. What I wanted to follow up about, we talked about the material fact. I wanted to ask if a seller has not a feeling, but let's say the seller, has never lived in the house, but they say, I don't think the AC works, right? Or it doesn't blow cold enough air, or it's really old and things like that. Or another one that we see coming up a lot is that there may be mold over there. Generally speaking, the people who say that are not mold experts. They don't know. So what I advise is just like you said, you can point and tell the buyer you want to investigate, but I don't think it's safe. And I wanted to know if you agree with me to make professional assumptions when you don't have any professional expertise.
I think that's a good point. If you don't know, I wouldn't educate yourself. If you're selling a property, you're a professional trustee or you're just the average person, I wouldn't go out and educate yourself necessarily and investigate all the various conditions. But I think it is appropriate to say, hey, there's a crack on the wall here. And just to highlight it and then leave it on the buyer to go investigate. But I certainly wouldn't be offering, and all the California Association of Realtor forms, all the disclosures all really shift the burden onto the buyer, but they don't let the seller out of issue spotting. This may be an issue, or I know this is an issue.
Yeah, one of the things, Zach, that I find always annoying, and this is from my business because I do a lot of open houses, is when an agent walks in with their client, they look at a crack on the wall and they say, "Oh, foundation issue." And I've been in this business long enough to know that you cannot, it's very rare that you can just from a crack, this is exactly what it is, because it's difficult to know unless they're specific things. So would you agree that it's better to, find out, what it is rather than making an assumption oh, that must be foundation or this must be that?
I mean, on the buy side, yes, obviously you want to do your due diligence and thoroughly exhaust that. And I would spend a little extra money as needed to investigate anything that's potentially an issue. On the sell side, I wouldn't necessarily go educate yourself. It's more, I almost treat it like the agent's visual inspection. If you're the agent, you're selling the property and you walk through and you notice something weird, point it out. That doesn't mean go hire the professional, just point it out so that the buyer can hire it. Or of course, if you've fallen out of escrow and you've gotten a report, then obviously you need to give that. So
very good. So this actually takes us on a very important segue, if you will. We have exempt sellers. People talk about exempt seller. You're an exempt seller because you're a successor trustee. Maybe you're selling your parents' home. You have never lived in it, or you haven't lived in it in 40 years or whatever. What does it mean to be an exempt seller?
It just means that you're not subject to the same statutory disclosure requirements. And there's a box you can check and you basically are not giving the disclosure. But it doesn't mean that if you're exempt and you move back in for 3 months and notice that the roof leaks, that you're exempt at that level. It's just you're not expected to have the same level. And part of it is to put the buyer on notice. It's hey, this is just a professional trustee or someone who lives in New York and is selling the California property that their parents had. They don't know anything about it. So you may need to do a little bit more because you're not going to get the traditional disclosures from them.
Oh, I really like that. I've never actually viewed it that way. It's kind of a way to put the buyer on notice and let them know, look, the person selling the house has very limited knowledge about it. That's very good.
It makes sense because imagine you do buy this house that nobody knows anything about versus if you buy my house, I'm going to tell you, hey, this is an issue, that's an issue. And I have more knowledge.
Yeah. So the exempt seller is not excused from disclosing what they do know. If they were present during the clean out, for instance, the removal of the furniture, and they see, that there is a huge hole in the living room floor, they shouldn't be, let's put carpet over it. They should be you got to disclose that there's a hole there unless you remediate completely.
Yeah, I would still mark the exempt box or whatever and let them know that, but then make the additional disclosure. We don't, we're not obligated to give you anything, but in abundance of caution, this is what we've seen when we walk through the house or something, if you had real knowledge.
Right. Okay. What constitutes real knowledge?
Well, it depends on your perspective. It could be what someone can prove you actually knew, but assuming you were to show up in court and testify under oath, it's what you actually knew about. And so, you can't speculate or I mean, you could, but I wouldn't, is my point.
Right.
So if you know that you were in the house and, the leaky roof's always the easiest one, and it rained and you saw water coming through the roof, then that would be some real knowledge. If you only went to the house on sunny days and you thought the roof looked a little bit suspect, that's not real knowledge that it rains or that there's water intrusion when it rains. So
that makes sense.
And that's why I'm always like, don't overeducate yourself as the seller.
Yeah, that makes total sense. Now let's talk about what are the consequences of failure to disclose that you have experienced in your professional practice?
Sure. So easy. I mean, there's a measure of damages. Basically, if a seller fails to disclose something that they knew about, that's can be a breach of the contract and a fraud or negligent misrepresentation. The measure of damages is the different, which is a little weird, but it's you pay $1 million for a property and then you find out that they failed to disclose some major defect. The way you value the damages in that situation is the difference between what you actually paid and versus a retroactive or retrospective appraisal, which would be done by an expert, and what you would have paid had there been full disclosure. And so the measure of damages is the gap between the two. So if someone said, hey, you didn't disclose the fact that the whole house is going to slip down a cliff, and you had a report and we paid $1 million, then you would go to an appraiser or an expert who would say, all right, here's the report. The house is going to fall down the cliff. What do you think it's worth? And they would say, well, with this full disclosure, it's worth 200,000. And then your measure of damages would be 800,000. I'm giving it hopefully an absurd example, but that would be an easy way to measure. Oftentimes, if you resolve the case, which is out without going to trial, it doesn't settle based on the measure of damages, which is set out in the civil code. I think it's 3343. It winds up usually settling something closer to the cost of repair, which isn't always the same as the fair market value reduction. So
that makes sense. Now, let me ask you another question. This is something that in our business sometimes comes up because lot lines are often uncertain. Like people say, where's the lot line? You say, and this is something I never answer that question. I say, without a professional survey, I cannot tell you whether the fence is on the lot line or not. But people ask it all the time. Does the lot go to the fence? Is the wall on the property line, or is the wall not on the property line? And if you saw, any properties that, especially in Palisades or places like that, where honestly, like they're always 3-4 feet off. So let's say a sale is consummated, and the buyer said, look, now the lot is, it's smaller than I was told, like this is not part of my lot. It's like, 5,000 square foot of that line, whatever, blah, blah, blah. Obviously wouldn't be that much, but unless it's a large property. But in those cases, how do you defend a circumstance like that?
So your hypothetical is someone sells a property and they say they somehow represent
during the sale, somebody says, is the wall on the property line? And the agent says, yeah, that's the property line. And then, that's the size of the lot. And then they find out that it's actually 5 feet encroaching on the neighbor's property. So it's, something happens and they have to tear down the wall or whatever. So they lost, like 300 square foot of lot. Is that a strong case for somebody to, do you feel like, get damages, or, do the reappraisal and say, well, the lot is not 5,000, it's actually 4,600,
Yeah, probably not. I mean, first, the buyer very few residential buyers, commercial tend to do it, but residential buyers actually get a survey. So number one, the agent shouldn't represent that a fence is on the property line. Even if you can see a marker in the ground, I wouldn't go there. I would say, I don't know, get a survey and figure it out. In terms of damages, if the agent did speak out of turn and say, hey, yeah, that the fence is the property line, then you would be getting into some complex areas of like easement and boundary law. It's pretty hard to lose your land. So So then it becomes a question of, are there damages if the fence is in the wrong spot? Is it too close in? You don't actually generally lose. No one's going to take that land from you, like 99% of the time.
Right.
The fence or someone may have an encroachment on your land, and that may have a different valuation because of that. But if you throw all of that out, I mean, I could spend hours on this subject. I do these cases all the time. If you throw all of that out, I would always go back to the buyer and be like, when you went to the property, you were willing to pay $2 million based on what you saw. And has that changed? Probably not, right? You may find out that you actually have 5 feet beyond the fence, but did it change your internal valuation of it? Probably not. So.
Right. That makes sense.
But now, people fight about these things like you wouldn't believe.
No, I'm sure. I mean, I see, lucky for me, I haven't had contentious transactions that have resulted in litigation, but I know that that there is always that chance that somebody may be litigious and things like that. I may find something with the property. So let me knock on wood, since I said no litigation. Let me ask you another question. In the case of, we represent professional fiduciaries a lot, and corporate trustees and those type of sellers. If let's say they receive an unjust claim for failing to disclose a material fact, what is your approach when a client comes to you and say, Zach, I've been accused of failing to disclose. What should I do now?
Well, typically, as the form requires a mediation, so I would always tell them that you're going to agree to go to mediation. The importance of that is because it preserves your right to prevailing party attorney fees. So in defending against an unjust claim, your best sort of stick in the fight is the fact that if you pay me to defend the claim, then hopefully I'll be able to win and recover you the attorney's fees you've spent on that. And there's various different mechanisms we can do in terms of defending a claim like that. But the first step is obviously making sure that if you win the thing, that you're going to be reimbursed and not out of pocket. There's other procedural tools that we can use to limit damages or to get rid of a claim quickly. There's a sanction motion that you could bring, which is pretty aggressive. Or if there's some nuisance value to the case, then sometimes we don't like to encourage that, but sometimes that's a cheaper way to get out. Instead of paying a lawyer a bunch of money, you give a little bit of money and the thing goes away. But oftentimes at those mediations, it's a shakedown, and the people that actually don't go beyond the mediation. And so, there's a school of thought that is show up at the mediation, offer them nothing, and see if they pursue it. Because a lot of times it's just they're going to go to those mediations and try to pick your pockets. And if you walk away from it, they may never do anything again.
Very interesting. And I have to say that you do see a lot of that, trying to get the seller, or the former seller, right, that sold, they maybe get, let's see if we can get a discount by bringing out this claim and things like that, which it's unfortunate. But I feel, and I want to get your opinion on this, Zach, I feel that, in California, the law may be skewed a little bit toward the consumer. And so, that caveat emptor thing, buyer beware. Well, you bought it, you did all your inspection. What do you want from me now? Sometimes gets, thrown out the window, and the seller is always on the hook. Is this only because I'm in the transactional part? Because you see a lot, you see what happens afterwards.
I probably have a different view. I mean, the contract is as is, meaning that, you're buying the property as is, and seller has no obligation to make it better.
Right.
But the seller still has a duty to disclose everything they know, even though it's as is. So I actually think the law and the way the CAR form in particular is written, it really favors the seller. It makes it very difficult for the buyer to come through with a claim. You're going to have to, I kind of view them as smoking gun type cases. You got to have this pretty clear thing. The seller knew, didn't disclose, and it was a material issue or material fact. But because there's so many disclosures that the buyer gets to the transaction of, you need to do your due diligence, seller's not representing X, seller's not representing Y. And so it doesn't mean a case is impossible, because I sometimes will do them on the plaintiff side. But with me, I'm pretty selective. You better have that smoking gun. And we get those occasionally where you're like, wow, you didn't disclose that there's a report about the cliff behind the house that says the whole cliff is going to fall down. That's it. I've seen that case twice.
Right.
So we do get those, but that's where I'm like, I got the report, and you're matching it up to the disclosures, and you're like, this doesn't add up. And that's like, so I think they keep strengthening the CAR forms. I know the guy at the California Association of Realtors that writes them, and they keep, those are seller friendly forms and real estate agent and broker friendly forms, because they're put out by the California Association
That
of
makes
Realtors.
sense.
They're designed to insulate.
Yeah.
So.
Very, very, very nice. Thank you for the clear answer about that. Now let's talk about you a little bit. Let's talk about your journey. Did you want to practice real estate law when you went to law school?
I would say not necessarily. It's sort of
Okay.
something that I got into a couple of years after law school, and I really enjoy it. I invest in real estate on the side. I'm like obsessed with it. So it's kind of one of those things that if you do something you enjoy, then I think you get better at it no matter what you're doing. So I have this real interest, and then I like practicing law too. So that helps.
That's wonderful. And what was your journey toward law school? Did you grow up in Los Angeles?
No, I grew up in Northern California, small town, Modesto.
Oh, okay, yeah.
It's like Central Valley. And I went to UCLA for college, and then went back to Northern California to Davis for law school, and then back down to Southern California, just bouncing back and forth. And I've been in LA. I've been running this firm since 2005, so about 18 years, almost 18 years.
Wow.
And I've been in LA for, I think, since 2000. Like, I haven't left since 2000, maybe, I don't know, must be 3 or 4, somewhere in that ballpark. So good 20 years practicing law in LA, and a little over 20 years practicing law in general. So,
Very
and all I
nice.
do is real estate, and I get brought into probate here and there, but it's always over real estate. Over, sometimes someone's fighting over ownership of real estate within probate.
You mean like things like partition action and things like that in probate?
Yeah, you can do a partition action in probate or outside of probate. I've done them both, but there is a section, the probate code, that allows them in the probate court. Sometimes we'll do there'll be an 850 petition or something, which is like the civil equivalent to a quiet title action. And the probate court can do those where, someone exercises some undue influence or forges someone's signature and then has the property, and then the probate court's trying to yank it back. So we've done a lot. I've probably done, I don't know, the last 5 years, maybe 3 or 4 probate trials themselves, where it's always over real property. So.
Okay. Can you give me an example of something they've litigated that involved probate?
I had one it was over this one went to trial twice because the judge declared a mistrial after the first one, because she had to leave the bench, so she couldn't rule on it. But it was over who got to administer the estate in it, which seems weird, but I was representing like a probate hunter. So I have a long-term client that goes out and buys gets assignments of beneficial rights in estates, and then he probates them, and then he basically flips the properties. And so we tried twice. He had done that, and he wanted to get his administrator appointed, and we tried twice as to who should be the administrator of the estate. And it mattered because we then would be able to ratify a sale. So that was like one contested one. Had another one where forged signature or allegedly forged signature of someone on their deathbed. Did another where there must have been like 5 or so kids contesting not their mother, but the fact that the father had given his wife, who was not their mother, the property, and they claimed that was undue influence, even though it was his wife. And so they were trying to get all the interest in the estate, or at least their proportionate share, and not have it go to her. So things like that, which involve real estate.
Yeah, very, very, very interesting. Now, before I let you go, I want to play, I have 30 questions that are general, back of the card type of things, back of the business card type of thing. That's what they call it. If you pick one number from 1 to 30, I will ask you that question, and we'll see what answer we get.
All right, let's go with 27.
Okay, 27. What was the last thing you regret buying?
I would say I bought one of those, I'm a little old for this, but I bought like one of those like hoverboard electric things,
Uh-huh.
which was kind of fun because I have younger kids and I thought they could bike and I could be along with them. But it wound up not being a good purchase. It just sat in my garage and it was I'm a little too old to be flying around on it. So.
Well, thank you very much for sharing that. Now, we are going to have in the show notes your firm's contact information, but if you want to let our audience know, what is the best way, anybody who needs help with real estate litigation or real estate matters, what is the best way to get a hold of you?
I appreciate that. And thanks for having me on the show. You can call my office general line, which is 310-954-1877, or you can go on our website, and there's all sorts of ways to contact me or intake or just gather information. We have a ton of info, a glossary of real estate terms and stuff like that. But the website is just www. and then my last name, so SCHORR, and then a hyphen and law.com. There's probably 400 plus articles on real estate. So it's also just a free resource that's out there for people that hopefully is useful. So.
That's great. Okay, Zach, before I end, I want to flatter you. I'm going to say something flattering because I really have to. I talk to a lot of attorneys. I really do. And you've done a great job at explaining to our audience some of the things that we wanted to talk about. And I really appreciate that. And I want to say something to our audience as well. It's just like with medical doctors, the general public, Zach, I tell you, they think that all attorneys are created equal. They assume that. And it's absolutely not. Just because you went to law school, it's absolutely not true. It's so important to have somebody who knows what they're doing on your side when you're litigating something. And Zach, I know you're one of those attorneys, so thank you very much for giving us your time and spending some time with our audience. We really appreciate it.
No, of course, and I appreciate you having me on the show. And I'm passionate about this area, so I'm always happy to chat with people. And thank you again for having me.
Yeah, absolutely. All right, everybody. Thank you for joining us for the episode. We'll see you on the next episode. Bye.